Hello, everyone. This is Aaron Gelb with Carey. I'd like to welcome everybody to the 10th installment in our Labor and Employment webinar series, 2019 Marijuana and Drug Testing Update. For anyone that's been paying attention to the legal trade or reading the HR press and following the news, you all know that drug legalization of marijuana and has been front and center in the news, and when you combine that with the opioid epidemic, this is certainly an area where employers are caught in many situations between a rock and a hard place in terms of trying to hire employees, figure out whether you should do testing, whether people are not going to apply. If you do testing, how do you do it legally? With the popping up of all different new state laws, city laws, county laws, regulations, it's a really difficult area and one where it's particularly important to stay up to date and keep track of the latest developments. So we're here to try to help you all to do that. We'll start with some brief introductions because we know you're here to hear content and not about our backgrounds too much. So I'll just let everyone know this is Aaron Gelb. I'm a partner in both the Labor and Employment as well as the OSHA Workplace Safety Groups at Conn-Maciel. I joined the firm beginning of last year in January of 2018. I head up the firm's Chicago office. I've been a management side labor and employment lawyer for the past 25 years. Attended University of Chicago and University of Texas School of Law. I divide my practice. I like to say I wear two different hats often on the same day. Handling OSHA matters, contesting citations, managing inspections, and also I've tried a number of employment cases across the country in New York and DC, Indiana, Tennessee, involving harassment and discrimination, military status discrimination. Also spend a fair amount of my time advising clients on and counseling clients through policy development, drug testing, procedures, training managers to do reasonable suspicion testing and the like. So with that, I'll let Dan introduce himself and then we'll get started.
Thanks, Aaron. My name is Dan Deacon, and I'm an associate at Carey, based in the Washington, D.C. office. And like Aaron, I also wear two different hats. I work with both the OSHA Workplace Safety Practice Group and the Labor and Employment Group. So I handle pretty much everything that comes in through the doors here, including representing employers during inspections and investigations for federal and state OSHA. And then I represent and advise employers in all aspects of labor and employment issues, including wage and hour disputes, claims of discrimination, and I also assist with a range of litigation related to those issues, in addition to reviewing and revising employee handbooks and workplace policies and procedures, including most notably drug testing policies, which we're going to be talking about in depth today. So with that, I'll turn it back over to Aaron, and he can go over the agenda.
Thanks, Dan. And Dan and I have worked closely on revising and updating drug testing policies and procedures for a number of clients the past few months. I certainly, from our standpoint, have seen a significant uptick in questions and issues that have come up with our clients, particularly as states in which we sit or areas where we sit are seeing these new laws being passed. So we'll start with an overview of both where federal law is and what the various state laws, notable state law changes that relate to drug testing in the workplace. This is one of those areas where the differences between federal law and certainly from state to state are very significant and impose some wildly different requirements on employers that make it particularly difficult for those of you that operate in different states. So we'll try to give you a sense of where those hazards lie and how to go about addressing those. Then we'll shift to a review of the drug testing restrictions that were promulgated as part of OSHA's new injury reporting and anti-retaliation rule. And then we'll shift over to talking about the Americans with Disabilities Act and how the obligation that law imposes on employers to proactively accommodate or provide reasonable accommodations to your employees gets tied up in the use of various drugs. So obviously, with respect, and we'll talk about this further, the ADA, it's with legal drugs and prescription drugs, but we're starting to see as state disability laws pop up and how they interact with the workplace drug testing laws and the laws legalizing certain substances. And then last but not least, we'll pay some special attention to the impact of state marijuana laws on employers as we see this growing wave of states that are adopting laws allowing either medical and or recreational marijuana. So let's start and set the stage a little bit and begin with some of the overarching questions about drug use, both in the workplace and obviously on personal time that can lead to impairments when your employees show up at the workplace. The questions that we typically receive most often from our clients are first, can we legally require our current employees to take drug tests? Obviously, that's typically one of the most pressing concerns, whether that's simply in an effort to limit the amount or limit impairment to cut down accidents, but also what to do in the event that somebody appears to be impaired or intoxicated. And it's one of these things, obviously, that you need to you're going to want to figure out and address before you find yourself in that situation. The last thing you want to do is be scrambling to try to figure out what's legal in your state or your county or your city when you've got an employee working out on the shop floor or in the warehouse or wherever you think may be impaired and you're not sure what to do about it. The next question, and one that isn't necessarily as pressing but can be equally important, is can you legally require your job applicants to take drug tests? And this is where we get into both practical and legal questions. As I said before, many employers are wrestling with this very issue because they know that if they are testing for drugs, and it's made clear as part of the pre-employment screening process that they may not even be getting the same level or quality or number of applicants because people are concerned or know that they're going to test positive. So then the question is, do we do it from a practical standpoint? If we're going to do it, how do we do it legally? And which ties into the last question. We are going to do these types of tests, and there are so many different circumstances or contexts in which you do testing. How do we do it in a way that doesn't run afoul of the law, both with respect to the substances that you're testing for, the methods that you're testing, what you do once you get a positive test result, and all those various considerations. So what are some of the legal concerns? As you can see from the graphic here, it often does feel to our employer clients that you're juggling a whole different host of issues here. And so while the state in which your company is located may allow employers to engage in drug testing, but your employees, your applicants, may still have legal claims based on who was tested, how the test was done, and how the results were used. So when you look at the different balls that are up in the air here, obviously one of the primary concerns or considerations is, are you violating state laws or procedures? So while you may have the legal right to engage in drug testing, you have to do so in a way that follows the requirements of your state or other municipality or county. So for example, in many states such as Maryland, an employee can bring a challenge against the employer who did not have a legitimate business reason to do the test or did not provide documentation that was required to be provided following a positive test result. Obviously, you can also face discrimination, employment discrimination claims. So an employer that singles out or is accused of singling out certain groups of employees, either based on race or gender or national origin or any other protected characteristic, could face a claim of discrimination. Then one that I think some employers don't readily recall or grasp quite as easily is invasion of privacy. So even though an employer may be allowed or even under certain regulations required to test for drugs, you may be violating employee privacy in a way that you conduct the test. So for example, an employer that requires employees to disrobe or provide a urine sample in front of others could face liability for invasion of privacy. And in that case, you certainly want to make sure, assuming you're outsourcing the drug testing that you're doing, to make sure that the protocols in place by that third-party provider are compliant with state and local laws. And when you're negotiating that provider agreement, you certainly want to look for some indemnification language to that effect. Last but not least, defamation. employee may have a valid claim for defamation if you publicize their positive test results. And while the employer has a reason to know, certainly if you have a reason to know that the test might not be accurate. So for example, if a retest showed that the first test that was administered was a false positive, or the employee appealed the first test, you could be liable for revealing the test results, the first positive test results beyond those who have a need to know about those results. So let's talk about some of the different, how drug testing relates to employment laws. So one of the first things, most important things to understand, and why one of the reasons that this area of law can be so challenging, is that there is no comprehensive federal law that regulates drug testing in the private sector. And this is an area where we're seeing developments in different, or there are different areas where we're seeing the same issue come up. So you all may have heard that there is noise in Congress, the U.S. Congress right now, some efforts to push and pass a nationwide law that governs restrictive covenants. So there's certain members of Congress that believe that this kind of patchwork of laws relating to restrictive covenants is problematic, inhibits the ability of employees to find work. Will we one day see some effort to pass a nationwide, uniform drug testing law? It's possible. We're not hearing anything towards those ends, and there are such wildly different laws across the 50 states. I think it's unlikely, but there certainly could be an initiative at some point because right now there is no federal law. The Supreme Court, however, has ruled that while drug testing does infringe on an employee's privacy, it can be necessary in order to protect the health and safety of others, both employees as well as the public. So with that Supreme Court ruling, obviously that ensures that employers will be able in some form or fashion to test for drugs, provided they are consistent with the laws of the state or the jurisdictions in which they're operating. There is, of course, and you may be sitting there saying, well, wait, you're saying that there is no federal law that governs drug testing. What about the Drug-Free Workplace Act? And you'd be right, that is a law, and that is certainly when Attorney General Sessions was in office, there was a lot of discussion about the fact that, what was he going to do, what was the Justice Department going to do about the fact that the various states that were passing laws legalizing recreational marijuana, because marijuana is still a Schedule I drug under the Federal Controlled Substances Act. But it's important to remember that this act does not require drug testing by employers. It simply requires a drug-free policy, and program is required for certain contractors. And it requires, for example, if you're doing business or your company is regulated by the DOT, the Department of Defense, that for those positions that are public safety or security covered positions, that you then have to have the drug testing program and conduct tests according to those regulations. The Drug-Free Workplace Act also imposes certain education and notice requirements in those companies that do business with the government. If that applies to you and you're not sure what those are, we're obviously happy to talk to you and walk them with you. And again, just keeping in mind that the Act, however, does not require you to do testing, nor does it restrict the types of tests, the methods that you test, or what you do with those test results, like we see in various state laws. We're getting here in Illinois, where I sit, and I'll talk a little bit more about this law later in the webinar. We are legalizing recreational marijuana beginning on January 1st of 2020. And so there has been a lot of conversation about, and questions that I'm getting from clients about, well, we're covered by the DOT, we have drivers, does that mean that we can't test for marijuana? So the answer to that is no, and that's, again, because the DOT regs require marijuana. It both prohibits its use and require testing for employees at numerous stages, so pre-employment, after an accident, if the employer has a reasonable suspicion that the employee is using marijuana, random testing, as well as return to duty or follow-up testing. It's also important to remember that the employers are required to obtain drug and alcohol testing information from any applicant's prior employer for the past 2 years. And the regulations promulgated as part of the DOT cover alcohol and drug testing, how it's to be conducted, as well as the mandatory random drug testing. And you'll hear, again, when I talk a little bit later about testing here in Illinois, that we're likely to see the random testing go away because of the nature and the requirements of that law. And we've seen that in a number of other states as well. Because drug testing kind of touches on so many different aspects of the employer-employee relationship, and so many different legal considerations are involved, this is one area where it's really particularly important to make sure that you're talking to attorneys or consultants who are familiar with all the different aspects, so you don't end up complying with DOT regs but missing the fact, for example, that if you have a unionized workplace, that you need to be mindful of the fact that if you are going to implement a drug testing program or protocol at your workplace, that the National Labor Relations Board considers drug testing, the implementation of a drug testing program, to be a mandatory subject of bargaining, meaning one that you have to bargain with the union as representative for your employees before you implement the program. And that any waiver of that right has to be subject to a clear and unmistakable waiver. So again, if you're unionized and you're saying, well, we don't have drug testing program, but I feel now is the need that we have to go ahead and implement one, make sure you talk with Labor Counsel and you go through the appropriate steps to notify the union and begin bargaining as necessary. Otherwise, you face an unfair labor practice charge. As I said before, I think that the greatest challenge with respect to drug testing is this patchwork of state laws. That said, keep in mind that, and I always start from the position, kind of the default position is that you generally have a right to test for drugs, and the question is, does my state or municipality or county impose some manner of restrictions on my right to test? So it's not that you should go into this analysis thinking like, does my state allow me to test, but assuming you're allowed to test, and you may not be in certain types of tests, what are the restrictions? And keeping in mind that this is an area where we're seeing, I would really characterize as fairly rapid and significant changes. So you certainly are not going to want to rely on a policy that you find online or that someone said that they used at their company 2 or 3 years ago or 5 years ago, because the changes are so frequent. And so whatever you can do or need to do to make sure you're keeping up with those changes is time well spent because of the rapid pace of change that we are seeing with respect to these laws. So with respect to the different the types of changes or the restrictions on drug testing, a number of states limit drug testing to reasonable suspicion or probable cause situations. As I said before, random testing is one area that seems to be fairly consistently under attack in those states that are looking at restricting drug testing. And if you try to understand where legislatures and those that oppose blanket drug testing is, you start from the position that in many cases, most folks that are out in favor of limiting testing will acknowledge or recognize that yes, post-accident, reasonable suspicion, if someone is bleary-eyed or bloodshot eyes and stumbling around the work, you as an employer should have a right to test them. But if the employee shows no signs of impairment, has a clean work record, hasn't had an accident, there are those folks that are more on the privacy side think that it's an impingement on that right to allow you to test them just randomly. A number of states impose restrictions on public sector employees, but not private sector employees, and a host of states then mandate or impose restrictions on the methods of testing, whether you're using blood testing or hair testing or saliva testing, what's done with the specimens, What's interesting, I think, particularly with respect to this patchwork of laws, is that it doesn't always follow the kind of the states that you see in many cases being either the most restrictive or the most libertarian, if you will. So there are some states that you would think would be very tough on drug testing that are not, and there are some states that you would think would be very lax and allow employers free rein that don't. So again, don't assume because you're in a state that doesn't otherwise impose many restrictions on employers that you have free rein to drug test your employees. So as far as, and kind of building on that, the types of testing, just to recap, so there's pre-employment, and so if you're operating in, if you operate in 30, 40 different states, and you want to roll out a pre-employment testing regime, that's one area certainly where you're going to want to look at. Some states require that an offer be contingent upon passing a pre-employment test. Other states require that employers provide written notice or indicate in their job posting that testing is required. One practical tip that we often put out there is that you really should make sure your employees don't begin work prior to the results of a pre-employment drug test. I know that probably sounds commonsensical, but we've gotten calls from a number of clients over the years where somebody fails the test after they've already started work, which makes for a rather uncomfortable conversation. Relatedly, random testing also varies quite frequently by state. So you see some states with no restrictions like Georgia, Virginia, Pennsylvania, some states that have some restrictions on random testing like Maine, and others that prohibit it altogether like Vermont. We see the cities, not surprisingly, San Francisco, Boulder, that do not allow random testing. Obviously, and this goes without saying as well, make sure that if you do have random testing, if you're allowed to do it and you are going to do it, that it's done in a way that it is pass muster and not be subject to a challenge that it's been utilized or imposed in a discriminatory manner. And so you really need to make sure you're looking at the selection process, who's in charge of it, how they're doing it, and if they're doing it in an appropriate manner. So with that, I will turn it over to Dan for a little bit to continue the presentation.
Thanks, Aaron. So now we're just going to get into a couple examples of drug testing laws, specifically a couple that are close to home here where I am in D.C., and we're going to start with the District of Columbia itself, which is changing as we speak, or there's proposals to change and regulate drug testing in private employment. So generally right now, as the law stands, it does not address drug testing in private employment other than for certain entities that contract with DC, with the government. So drug testing is not prohibited or restricted unless it violates other legal provisions. With that being said, there are some nuances. For example, you cannot drug test until after a conditional offer is made. That was one of the points that Aaron just made. With that being said, however, there are certain laws that are proposals that have been introduced in the D.C. City Council as it relates to recreational marijuana and medical marijuana. Two different bills proposing to eliminate marijuana testing in the workplace. One, eliminating marijuana testing altogether, and the other related strictly to medicinal marijuana. So no drug testing those employees who have a valid marijuana prescription. In DC right now, marijuana is decriminalized. Residents can grow their own plants if they choose to do so. And there are medical marijuana dispensaries all over the city. However, there isn't anything specifically related to drug testing in the private sector in any of those laws. So those are circulating through the D.C. City Council right now, and we expect something to arise out of those at some point in the future, especially with the growing trend of social acceptability of marijuana, and especially medical marijuana. And one interesting note there is D.C., I don't know if a lot of people are aware of this, but it's home rule government, so everything that the D.C. City Council passes has to be reviewed and approved by our federal government. So it's really interesting to see the progressive laws that DC City Council puts out and actually gets approval and kind of waived by the federal government. Some things that probably wouldn't ever happen on the federal level, at least right now. Moving on to Virginia. Virginia is very similar to DC currently as it stands. It does not address drug testing in private employment other than those employers with government contracts. So it's not prohibited or restricted, again, unless it violates other legal provisions. However, this is one of those states where you do need to provide a notice, an acknowledgement form to employees about drug testing and pre-employment drug testing. And then again, employers that contract with the Commonwealth of Virginia with state contracts over the value of $10,000 are going to have to implement a drug-free workplace. So there are some certain nuances in that state law as well. Moving on to West Virginia. West Virginia legislation does not address drug testing in private employment either, but this is one of those scenarios where we see the court step in a little bit. So the West Virginia Supreme Court issued an opinion back in the early 90s that found an employee's right to privacy may be paramount. So in that case, the court found that random drug testing was an invasion of privacy, one of those legal concerns that Aaron reviewed early on in the presentation. With that being said, though, the court outlined two exceptions. One, if the drug test was based on a reasonable, good faith, and objective belief that an employee was using drugs, or two, if the testing was limited to employees whose job duties involve public safety or the safety of others. So, although employees received that protection under the privacy concerns, applicants did not receive or do not receive the same type of protections. In 2003, the West Virginia Supreme Court issued another opinion requiring job applicants to submit to a drug test, ruling that it is not a violation of an applicant's privacy. So what we gathered from that is an applicant's expectation of privacy is not as significant as an employee's privacy expectations, and the employer's interest outweighed the applicant's right to privacy. So the pre-employment drug testing in that case was upheld, and it's fine. So when you're looking at a state like this, such as West Virginia, although you may be an employer there and you have a pre-employment drug testing policy, again, you want to keep in mind those other legal concerns, the disability discrimination piece, invasion of privacy, which we just went over here, though, defamation, and then other types of discrimination claims if you're only drug testing a certain age category or gender or race, something protected under Title VII. So now we're going to get into some of the OSHA issues. A lot of people might think, oh, okay, we've been talking about all these state laws, and there's variations throughout the country and types of protections that employees might get, what types of tests may be conducted, what types of tests or what types of substances you can test for, but there are also these OSHA protections, and they're specifically related to post-incident drug testing. So this is OSHA's not-so-new rule anymore. This was promulgated back in 2016. However, it's had a long and tumultuous history. When it was passed back in May 2016, it had two components to it. There was an electronic record-keeping portion and an anti-retaliation portion. And what you see on the screen here are the two major provisions related to the data submission piece. And that was establishments, so single physical facilities, with 250 or more workers were required to submit their OSHA 300 logs, their 301 incident reports, and the 300A annual summaries. And then establishments with 20 or more workers in high-hazard industries were required to submit their 300A annual summaries. In addition to this electronic data submission requirement, we had a set of anti-retaliation provisions that were related specifically to reasonable reporting procedures, so reporting injuries and illnesses to the employer. The two major anti-retaliation provisions that received the most backlash from industry were related to safety incentive programs, so bonuses and the like that are tied to achieving certain rates, injury and illness rates, and then post-incident drug testing, or drug testing in general. So in that rule, it wasn't outlined specifically in the regulations, but if you went to the preamble, the hundreds of pages that the agency publishes when promulgating a rule kind of explaining the details, there was this piece about post-incident drug testing. And their theory was that drug testing can dissuade a reasonable employee from reporting a work-related injury because it is an invasion of privacy. So what we gathered from that preamble language, and it was really just a couple paragraphs within the preamble, was that post-injury drug testing could not be a form of discipline. And the one hard and fast rule that was born out of that is blanket post-injury drug testing policies were strictly prohibited. So if you were an employer and you had a policy that said any employee that's involved in an accident is automatically drug tested, that was all of a sudden violative of this new OSHA rule. What the OSHA rule did, however, permit was what you see on the screen here, a host of things. It really only affected post-injury drug testing. So pre-employment drug testing was unaffected. Random drug testing was unaffected. If you were drug testing to comply with a state or federal law, a requirement within that law, for example, the Department of Transportation, mandatory post-accident tests, that was permissible. And then also if it was required by a workers' compensation insurer for premium reductions and stuff like that. And the final one that you see on the screen here in italics was post-accident drug testing is permissible when the accident, when drugs likely contributed to the injury and where the test can ID present impairment. So there was a lot of backlash about this provision because there was no guidance in how to implement it, right? First, when we're talking about the last part there, testing that can identify present impairment, there really wasn't anything, and to my knowledge, there still isn't anything that can identify present impairment for a number of different drugs, right? So it really pertained only to alcohol. But what are we going to do for marijuana, cocaine, amphetamines, and the rest of this stuff? So as this rule continued and industry put up a lot of backlash about it, there was 2 different lawsuits filed in Texas and Oklahoma challenging these rules, one related to the data submission piece and the other related to the anti-retaliation provisions, especially the post-injury drug testing. So shortly after the rule was promulgated, about 5 months later in October, a memorandum was issued by the agency providing a little more context, if you could describe it that way, of how to conduct these post-injury drug testing. And what we gathered from that was that the rule prohibits drug testing employees for reporting work-related injuries without an objectively reasonable basis for doing so. So this post-incident drug testing law really, the message that we were getting from this memorandum was that it can be used as a tool to evaluate root causes of a workplace injury. And the inquiry that we gathered was the 4 bullets that you see on the screen here, the 4 factors that you as employers should evaluate in determining whether you have a reasonable basis to believe that drugs or alcohol could have contributed to the injury. One being whether the employer had a reasonable basis to conclude drugs or alcohol could have contributed to the injury, which is very circular and doesn't provide much context at all. So again, we get this memo and it's supposed to be providing us information and guidance about how we can make this analysis and basically they repeated exactly what was in the rule. 2, whether other employees were involved in the incident, whether they are also tested. So you don't want to just be testing the employee that was injured, for example. Whoops, we went too fast there. 3, whether there's a heightened interest in identifying drug use because of high hazard work. So again, if you have heavy machinery or equipment and it's a safety sensitive position, that might weigh in favor of the drug test as well. 4, whether the drug test is capable of measuring impairment at the time the injury or incident occurred. And OSHA clarified that factor was only going to be considered for alcohol tests. So it did not affect an employer's ability to test for other substances, notwithstanding the test inability to measure present impairment. So there was no impact on what types of drugs you could actually test for. So OSHA offered this following example that you see on the screen here to try and provide some more context about when and when you can't do this. So the first one that we have from this memorandum was that a crane accident injured several employees working nearby, but not the crane operator. The cause of the accident was unknown, but it's possible, reasonably possible, that it was caused by the crane operator error, one of the spotters, or it could have been a rigger's error. So in that case, it's reasonable to test all of the employees whose conduct could have caused the incident, regardless if they were injured. If it could have been any one of those, the operator, the spotter, the rigger, you're not sure, but you're using it to evaluate the root cause of the incident, there you're going to want to test all of those employees. Don't just single out the one that was injured or the one that you might believe that contributed to the injury or incident. And the other piece to this is, and some of the examples that we got just in the preamble, it wouldn't be reasonable to test an employee who reported an injury or some type of illness that's a result of, for example, an allergic reaction to a bee sting, or if they complain or report a repetitive strain injury or a MSD, a musculoskeletal disorder. In those cases, it's not going to be reasonable to conclude that drugs or alcohol contributed to the injury. I suppose, it may be possible, highly unlikely. Again, this is a fact-specific inquiry, but if someone's complaining of a back strain or they were stung by a bee, unless they were doing something that they really weren't supposed to be doing, sticking their hand in a beehive, something like that, it's probably not going to be reasonable to drug test those employees for reporting those types of injuries or illnesses. So what do we have with the rule today? Well, there was this industry backlash, right? I mentioned the 2 different lawsuits that were filed, the one in Texas related to the anti-retaliation rule. The main arguments there were that OSHA didn't show the anti-retaliation provisions would reduce injuries, and there was no APA required regulatory impact cost benefit analysis. So what happened in this case is the parties moved for preliminary injunction to bar enforcement until the district court ruled, and OSHA had asserted that irreparable harm could not be shown in their defense, and the case was stayed. What happened between when this lawsuit was filed and where we are now is we had a presidential election, and with that came a transition to a new administration. So when the Trump administration came in, it withdrew the motion to dismiss that was previously filed by the Obama administration and requested a stay of the case pending a notice of proposed rulemaking. Because they were reviewing the rule, we thought, okay, there's going to be a lot of changes coming in the near future, especially as it related to this rule. Remember, at the beginning of the administration, we had a fury of different executive orders about slashing regulations. He used the Congressional Review Act to immediately slash some of the midnight-era Obama rules, and it was off to a hot start in cutting regulation. But what we got was a watered-down notice of proposed rulemaking that eliminated just one minor section of the data submission requirement, that being the requirement for large establishments, those with over 250 employees, to submit their 300 logs and 301 forms. So really it didn't touch the anti-retaliation provisions at all. It didn't change the rules about post-incident drug testing, and those are still in effect. So OSHA actively pursues those violations. We typically only see them where there's an aggrieved employee, so they're reporting the incident to OSHA. For example, if they were involved in an incident and they were singled out for drug testing and there's an issue with implementing that post-incident drug testing policy, that's where we typically see OSHA come in. It's going to be through an employee complaint. So again, that legal challenge, it was stayed, but we expect that to resume on the active docket. It's still ongoing. Like I said, the notice of proposed rule and the final rule that was issued, it was issued about, 8 months ago, back in January 2019. It did not affect or address the anti-retaliation provisions at all. So we can keep an eye on that legal challenge to see if anything comes out of that challenge as it relates to post-incident drug testing. With that, I'll turn it back over to Aaron to address some of the ADA issues.
Thanks, Dan. And you may be sitting there listening, thinking, well, the ADA doesn't protect the illegal use of drugs, so why are we talking about this? And you'd be right, it does not. So usually taking methamphetamines or because marijuana is a controlled substance under federal law, smoking marijuana, none of those would be things that you would need to accommodate, obviously, under the ADA. But we're not talking about abuse of drugs. We're talking about the use of prescriptions to treat conditions. And so because of that, that's where we found that disability discrimination can be one of the most significant risks when it comes to deciding whether or not to engage in drug testing. And here, again, we're talking about more so not that you are testing or necessarily what you're testing for, but how you're doing the tests or how your third-party provider is doing the tests. Drug testing is allowed because the ADA doesn't protect drug abuse. So there's this distinction between use and abuse. And just because someone tests positive for certain opioids, if they are prescribed, that doesn't mean that you can refuse to hire them necessarily. It may depend obviously on the type of position that they're applying for, if they're going to be using heavy equipment, if they're going to be working in safety-sensitive positions. But like any rule with respect to the ADA, obviously one of the most important considerations here is evaluating each situation on a case-by-case basis. Have you ever heard any HR expert or lawyer talk about the ADA? That's going to be one of the most important steps that you can take, both in terms of developing a process for addressing these types of questions or concerns and developing your policies, making sure your managers understand simply because somebody has the need to take or is prescribed a certain type of medication doesn't automatically, in many instances, preclude them from a certain position. And you're going to have to go through an analysis in each instance, perhaps dialoguing with a doctor or a physician to understand the impact of those substances, alternative positions that you might place the person into, et cetera. So that's really kind of one of the more important considerations with respect to the ADA, and again, we're talking about lawful drug use here. Particularly one area or one consideration, if an employee is fired or an applicant is denied employment with your company because of a positive drug test and the medication was prescribed legally. So again, we're not talking about someone who may be abusing prescription medication, which obviously is a significant issue with respect to the opioid epidemic, and hopefully the testing that is being done of either of your applicants or of your employees can determine the amounts and the concentration. As Dan said, it varies from substance to substance. If anyone hears of someone, you have a friend who's developing a test that will test present impairment of marijuana, I'd encourage you to invest heavily in that business, because I certainly think that the first person that does that is going to be very successful, because that is obviously one of the greatest challenges that employers face of the various substances out there. Marijuana is one that we can't determine right now, present impairment, but there are other substances where the levels and the amounts with respect to prescription medications would indicate abuse, and that's where the protection disappears from the ADA when you cross the line from prescribed use to abuse. With respect to the ADA, obviously this isn't an entire ADA presentation. I will make a little commercial. Our webinar next month is going to focus on the Americans with Disabilities Act, primarily on the reasonable accommodation and interactive process. So if that's an issue that you want to learn more about, please tune in next month. I'll be doing that one as well, and I think it should be a helpful program. But briefly, for the purposes of today's program, just understand, obviously, the ADA applies to all aspects of the employer-employee relationship, but also to the application process, the onboarding and hiring process, as well as during employment. And I'm sure that everybody listening is familiar with this, but as you know, that employers are required under the ADA to make reasonable accommodations that allow your employees who have disabilities or applicants that have them to apply and be considered for jobs, as long as the accommodation does not cause an undue hardship on the company. And that does include, and this is where we talked earlier about one of the real concerns with the ADA and drug testing, is that accommodations may be necessary during the pre-employment drug testing process. And those employers that stick with and adopt rigid rules tend to find themselves in a little bit of hot water, as we'll talk about in the next couple of slides. One recent lawsuit involving Kmart involved an applicant for a customer service position whose offer was revoked because he could not provide a urine sample. Lawsuit was brought accusing Kmart of violating the ADA. Ultimately, the company agreed to settle for $102,000. The facts there: the applicant had a kidney disease and was undergoing dialysis at the time that the individual had applied for employment with Kmart. Allegedly, this individual expressed willingness to take a different type of drug test. As I said before, there are many types. This person had offered to take a hair or blood test. Kmart denied this request as a requested accommodation, insisting that every new hire had to complete the standard urine test provided at its facility. And this gets back to, again, this rigid adherence to a certain approach or a certain rule. It may have been that Kmart felt that we're a big company, and if we make exceptions here, we're going to have to make exceptions other places. But I'd assume and like to believe that this is one of these situations where if you really step back and take a look at the situation, and is that an undue hardship on the company? Obviously, they must have felt that there was some concern or some risk to taking that position once the matter went forward, and they ultimately ended up, as I said before, paying $102,000 to settle the case. They also agreed to revise their drug and alcohol-free workplace policy and their pre-employment drug testing policy to include a description of the company's obligation to provide reasonable accommodations to employees or applicants in the testing process. Another big box retailer got in similar hot water over this issue. Walmart had offered an applicant a sales job and required her to take a drug test. She had said that she had end-stage renal cancer, which prevented her from taking another individual with a challenge taking a urine test. In this case, Walmart withdrew her offer after she couldn't take the test within 24 hours of the company's request. And these facts, as you can glean, are quite similar to those in the Kmart case. She had also allegedly requested another type of test, was told that corporate would not allow an alternate test. So as a result, the EEOC sued Walmart for violating the ADA. Yeah, and this is again one of these situations. Was corporate really made aware of this? Was this more likely a manager who just assumed that the corporate takes a rigid position on certain issues and did not bother to run that request up the chain to find out if indeed that the change could be made? This is an issue that I see time and time again, particularly in cases brought by the EEOC. I try to keep track of EEOC litigation in this area. One of the things that the agency has been doing as part of its strategic plan over the last few years is really focusing on, under the ADA, under barriers to entry or barriers to employment. And certainly they look at the pre-employment processes as one of the more significant ways that disabled individuals are precluded from gaining employment. And so they do really focus on these types of policies. And there are a number of cases that I've seen where it's the frontline manager that really makes the mistake, and usually without running it by someone at regional or corporate. Cases with refusing to bring a translator in for a deaf applicant because they didn't think that they would be approved, but within the context of these drug cases, refusing to change or modify the manner in which the test is administered. So we're not talking about an employee or an applicant has refused to take a test, but just asking for an accommodation. So that's another issue to keep in mind here. Now, what about when it's medical marijuana? So in this case, out of state court in Massachusetts, so again, we're not going to see medical marijuana at this point coming up under the ADA because that's federal law and it's still a controlled substance under federal law. But we're seeing more and more in state law, in state court, these types of cases being brought. So in this case in Massachusetts, Barbudo versus Advantage Sales and Marketing, the court held that the plaintiff was disabled and rejected the company's claim that her use of an illegal drug under federal law rendered an accommodation facially unreasonable under that state law. In reaching this decision, the court relied on language in the state's, in Massachusetts, medical marijuana law that prohibits the denial of any right or privilege on the basis of medical marijuana use. I think importantly, the court held that where a handicapped employee needs medication to alleviate or manage the medical condition that renders her handicapped, and the employer fires her because company policy prohibits the use of this medication, the law does not ignore the fact that the policy resulted in the person being denied employment because of her handicap. Notably, the court declined in this case to provide a private cause of action under state law or wrongful termination given the remedy under discrimination law. So the defendants in this case did not argue, interestingly enough, federal preemption. So now let's shift a little bit and talk about the marijuana laws and the significant changes that we're seeing there. Before we do that, just to give you some statistics, and I think they're very telling. If you look, so in one poll that Gelb took back in July of 2017, they found that 45% of Americans have tried marijuana and 12% were actively using it. So that basically translates to 1 in 8 people currently smoking or marijuana or using THC or the various byproducts. And this, just for frame of reference, is the highest percentage of people who have tried marijuana since 1969 and that era when obviously it was, I think, a little bit more before obviously the Just Say No era. Use apparently is higher among men, and I think probably most significant in my view as far as forecasting ahead and what we can expect to see and what the types of laws that employers may be facing is that increasing numbers of people in both parties favor legalization. So the Republican and Democratic parties may not agree on a whole lot, but apparently legalizing marijuana is one of the issues where there is greater and greater consensus. Also notable in a poll, the Gelb poll taken last year, they found that 65% of Americans believe smoking marijuana is morally acceptable. So when you tie all those statistics together, I think we're only going to keep seeing more and more states legalizing recreational marijuana, and perhaps at some point in the not too distant future, we may even see a change in the federal side. just to give you some quick numbers with respect to legalization of marijuana so far. Our last check, 33 states and the District of Columbia have legalized marijuana for certain medical conditions or certain medical uses. And if you go through the list and you find your state on there, or certainly more likely that you will than you won't, given that it's 33-17. But significantly, many of the largest states, California, Florida, Illinois, Michigan, Pennsylvania, New York, New Jersey. And this is a trend, obviously, that's only going to continue. Meanwhile, recreational marijuana, we are now up to 12 states that have legalized it. Illinois and Michigan being the most recent, Colorado being one of the first. And we're certainly seeing, I know from talking to employers in Colorado, they are facing challenges. I think there are unanticipated side effects, or maybe some that were anticipated, but it's become a real struggle for employers that are looking to maintain a drug-free workplace in states like that. The next slide, again, I'm kind of at ground zero for this and have fielded a ton of calls because Illinois employers are concerned, and rightfully so. I'm one of those lawyers that will honestly say that in many cases lawyers are guilty of kind of drumming up fear and trying to convince clients that the sky is falling with the latest new legislation that's coming down the road and you need to hire a lawyer because this change is significant. In many cases, that doesn't come to play. I always look back at Y2K and some of those issues that never really became what people were hyping them up to be. But for Illinois employers, this is a big deal, and I don't think there's any way around it at this point. So the law that's going to go into effect in January of next year, so just a little more than 2 months away, the Illinois Cannabis Regulation and Tax Act. There are a number of, I've really just tried to bullet point the key considerations here. First, this law amends another state law meaning that marijuana use is explicitly protected when used off-duty. And this is kind of a step that when I say Illinois ups the ante, this is taking kind of a step further than a number of other states that have legalized marijuana but not really done anything that protects employees who might then test positive. And what this means to protect lawful off-duty use is that you as an employer cannot take action against somebody for something that they did that was lawful when they weren't at work. So if somebody gets high on Sunday or Saturday or Sunday and comes into work on Monday, provided they're no longer impaired, they are not breaking. That is lawful use, and you can't take action simply because they test positive. For those if you do administer a test and the person tests positive, you then, in order to take any action against this individual, the employer have to have a good faith belief that they are impaired at the time of the test, and that there are a number of indicia or criteria that are set forth in the Act that are what your managers or supervisors need to look for. And they're going to need to be trained so they can identify and document that, because without that contemporaneous impairment or belief of impairment, you can't take action. What I'm expecting also, given that combination, the need for a positive test and impairment, I'm expecting pre-employment and random testing to go away here in Illinois, because unless you happen to be able to confirm that the individual is impaired at the time of a random test, simply sending someone for a test that comes back positive without that contemporaneous impairment is not going to be sufficient to take action. If once an employer does take action, they have to provide, because an employee, or before you take action, if an employee has tested positive and appeared impaired at the time, you still have to provide them a reasonable opportunity to contest the findings. What that means, what it looks like, isn't quite clear yet. We don't have any regulations from the state that kind of explain how that's supposed to be done. Small little saving graces here. This does not affect, as I said at the outset, DOT testing. It doesn't prohibit employers who wish to prohibit use at the workplace, possession at the workplace. It doesn't prevent you from adopting and implementing a drug-free workplace program, but you just have to kind of fold in the protections that are now afforded to marijuana use. With that, I am going to hand it back off to Dan. Thank you.
Great. So now turning to medical marijuana at the workplace, and there's a lot of questions that arise under those issues, right? There's recreational marijuana, and then on the other hand, medical marijuana, and how those are treated under the law varies. And of course, as you've probably gathered from this presentation, it really depends on state law. But generally, just as something to keep in mind is that marijuana itself still remains illegal under federal law. Although states have legalized some form of marijuana use, including medical marijuana, it still remains legal under federal law. And drug testing, although state laws have different restrictions on what you can test for and so forth, employer policies related to marijuana can typically take a hard stance on those, except for those states that have specific employment protections. For example, Arizona, and you'll see on the next slide a host of states that have specific anti-discrimination statutes related to employees or persons that have a valid prescription for medical marijuana. So despite all those laws, employers generally remain free to set their own drug testing policies and discipline and terminate employees who violate those policies. However, as I said, there are certain anti-discrimination statutes, and those are the states that you see on the screen here: Arizona, Delaware, Connecticut, Illinois, Maine, Minnesota, and Rhode Island. So for example, Arizona's law prohibits discriminating against a valid cardholder, prescription cardholder, for testing positive for marijuana unless they used, possessed, or were actually impaired on the job by marijuana. So the overarching question that we get, and perhaps the most pressing question that we get from employers, is whether they can lawfully impose discipline, including termination, on an employee who tests positive for marijuana. So the answer there, of course, varies depending on the state in which you are located. There's going to be a lot of different factors at play here. So does the state permit recreational marijuana? That's your first question. Does it permit medical marijuana? That can be your second question. And of course, the follow-up to that is, are there statutory protections for valid marijuana cardholders, prescription cardholders? So the answer generally, however, is yes. Most states do allow employers to prohibit the use of marijuana on the employer's premises as well as on-the-job intoxication. So if you're dealing with an employee that comes to work high, or you find them smoking on the job, or you find a substance in their possession, that is something that you can use as the basis to discipline that employee. That is perfectly acceptable. And then there are some states and some case law supporting the employer's right to terminate an employee for testing positive for marijuana. Remember, it is still illegal under federal law. What is trickier there is, of course, if you don't see any impairment on the job, you don't catch them or anything like that. If you're just running a drug test and you don't have those additional factors and signs, there's certainly some more questions that you have to ask yourself on whether you want to discipline the employee in that case. So the key question here is, can an employer discipline the employee for off hours and off-site use or influence, right? So if you don't catch them on the job, you don't find them smoking on the job, anything like that, what do you do for their off-duty conduct? And this is something that's been developing in the law for a while now. So what happens if it's pursuant to a valid prescription, right? You drug test them, they have a valid prescription. in a medical marijuana state, there the answer is probably no, right? There's a host of states that have those anti-discrimination statutes, and even if they don't, you might be running up against potential disability discrimination issues under state law or perhaps even the ADA. Again, that area of the law is developing and changing, and there's various different opinions out there as it relates to medical marijuana card holders. If it's for off-hours and off-site recreational use in states that permit recreational marijuana, there you can discipline those employees for their off-duty conduct typically. Again, if there's no statutory protections, and to my knowledge there aren't any statutory protections for recreational use, you can still maintain that zero tolerance policy. So again, moving on to lawful off-duty activities and continuing with that, in those states where an employee who tests positive for marijuana can potentially claim he's protected from termination so long as his use of the drug occurred during non-working hours. So typically, lawful off-duty statutes are statutes aimed at protecting employees' rights to free speech, and they can't be fired for engaging in political activities that their employers may disagree with. However, those statutes also apply to personal and lifestyle decisions. So there are certain statutes out there that can be morphed into certain protections, and case law, again, is developing and addressing with that now, and it varies by state. So you may run into cases for those lawful off-duty activities, and you want to check your state law to see if there's any opinions or specific statutory protections for lawful off-duty conduct. Again, it may not specifically be related or tied directly into the use of marijuana, but there may be certain privacy or statutes related to lawful off-duty activities that can be morphed into legal claims related to marijuana. So this issue of lawful off-duty conduct was addressed by Colorado Supreme Court in 2016, and this is one of the more notable cases. The plaintiff there claimed that his position wasn't hazardous. He wasn't in an executive position that would require decision-making or anything of large importance, and perhaps the most important piece to this, he said that he was never under the influence of drugs at work or on the company premises. He also claimed that his employer knew of his status as a medical marijuana patient when he was hired, and that essentially made their claims of the zero-tolerance workplace policy invalid. So the employer, on the other hand, here, they asserted that it is they, as the employer, are lawfully entitled to enforce their zero-tolerance policy, and in any event, even though marijuana is explicitly legal under Colorado state law, marijuana usage cannot be considered lawful off-duty conduct due to its status under federal law. It is still an illegal substance under the Controlled Substances Act. So what the court did here, it upheld, or I shouldn't say upheld, but it affirmed the employer's argument and adopted that, and upheld the decision for the employer and found that the termination decision was lawful. So the outcome of this Coates case is significant for employers, of course, in all states, given that Colorado has been at the liberal forefront of legalizing marijuana, and the fact that the Colorado Supreme Court affirmed the ruling in favor of the employer. That, of course, strengthens the right of employers in a lot of states to terminate employees or otherwise discipline them for failing to pass a drug test as a result of marijuana use, regardless of that legality of the drug under state law. But given the growing nationwide trend, of course, laxing the laws on marijuana and the additional protections for marijuana users under certain state laws, many employers many employers are reassessing those zero tolerance policies and taking a different position and relaxing them and making some exemptions for marijuana use. So in analyzing the drug testing policy that you have as an employer, here's some practical aspects that you should be considering. Will a zero tolerance policy on marijuana reduce my pool of qualified candidates to an unacceptable level? There's a lot of industries right now that are facing labor shortages because of drug testing policies and the inability to find employees that can pass a drug test. So that is an issue for a lot of employers in certain areas of the country and certain industries. 2, will failing to test for marijuana increase workplace injuries or absenteeism? Of course, if you have a lot of safety-sensitive positions, that's certainly going to impact your decision-making on zero-tolerance policies and the acceptable use of marijuana within that policy. And finally, will treating marijuana differently than other illegal drugs create problems for my workforce? So what we've seen over the course of the past 4 or 5 years or so is more flexibility and less bright line zero tolerance policies, especially in those states where medicinal marijuana is legal, and of course where there's statutory protections, and those states, of course, that have decriminalized or where recreational marijuana use is acceptable. So a lot of employers are softening their zero tolerance drug policies, particularly for those jobs where safety isn't an issue. It's not an essential function. You're not out on the manufacturing floor, for example. State laws allowing marijuana use are complicating recruiters' efforts to find drug-free employees. Again, that relates back to the labor shortages I mentioned on the last slide. Low unemployment and increasing use of drugs, narrowing those pool of qualified workers and applicants. Before relaxing zero tolerance policies, however, you want to attempt to get buy-in from company leadership that supports the move and how to deal with any consequences that might arise from changing that policy, right? Going back to those practical aspects on the last screen, you want to consider how that's going to impact your workforce and consider those risks and the risk tolerance for potential litigation. And then just the last bullet here, no changes in employer policies or practices should excuse an employee who's impaired while working. That should be clear in your policies, regardless of whether you take a lax position on marijuana or not. Regardless of that change in policy, employees under no circumstances should be at work or working while impaired under any circumstances. So with that being said, the presentation is over today. Apologies, we went over about 13 minutes or so. But if you all have any questions, feel free to type them in the chat box or follow up with Aaron or myself after the presentation today. We're going to be sending out a copy of the slides and a webinar recording to you all by email shortly following this webinar. And feel free to tune in next month. As Aaron mentioned, we're going to be performing a webinar on reasonable accommodations and the Americans with Disabilities Act. So, and thanks for tuning in today, and hope to see you soon. Thanks.